You broke up a little bit. Was the question about the jail and the inmates?
Yeah, what's the status of the jail right now?
Yeah, this was an issue early on because you saw a lot of some of the jails around the state were releasing inmates to reduce the jail population. I guess they thought they were going to have a problem with the pandemic in the jails. So early on, my commitment was I am not going to release anybody from the jail, and there's a multitude of reasons for that. But basically, number one, because they've committed crimes. Number two, they've already been in front of a judge who decided that they need to stay in jail. The third thing is, in the jail, we have excellent health care. We have had, and knock on wood, we've had no inmates that have tested positive or exhibited any symptoms of having the virus. And we take a lot of precautions. So they get excellent health care. They get excellent food service under very stringent sterilized conditions. I mean, this is not the first go round that we've had with problems where we have to address epidemics in the jail. We've been through the SARS, we've been through H1N1, we deal with MRSA all the time. So we're fully prepared with our healthcare system in the jail and the way we do business to make sure that we're not going to have that infection spread through the jail, and we haven't had that. We've actually had one of our employees who was a sergeant in the jail that passed away, but he had other underlying health conditions and traveled. So the bottom line is the jail is only at half capacity. I have plenty of room in there. We are providing the inmates, they will be provided with 2 of the cloth masks that the inmates are actually making there. They're sewing and making the masks. So we've got a lot of conditions there that are very conducive to having safety for the inmates. So there was no reason for me to release anybody from there. Now, the meeting that I had with the chief judge, the public defender, and the prosecutor was, if they wanted to determine that there's people that should have lower bonds that should be out for some reason, that's fine. But I'm not releasing anybody from the jail. The jail is fully capable of functioning the way they are. And again, we're only at half capacity. Our capacity is 3,200. We're around 1,600 right now. And even somebody bringing somebody to the jail, that inmate has to be tested before they're allowed to enter. And the law enforcement officer that enter has to have a mask and gloves on, and they go into a sterile area and they're checked by an infectious disease control doctor and an RN. So I think that the jail's in good shape. And like I said, knock on wood, we haven't had anybody test positive or have any of the inmates that have showed up with any symptoms.
Okay, thank you. I have one more question for you before we keep circulating through the panelists. I don't know if that is my audio. Sorry, you guys, if it is. But so Sheriff Bradshaw, so what, hopefully this makes sense. I'm not a criminal defense attorney, so I have to admit, I don't know all of the ins and outs of the sheriff's role in the court system. But there was a question asked that what is the status of the Palm Beach Sheriff's Office's role in our court system and daily operations?
Well, we still fully staff the courtrooms that are operational, and the courthouse is fully staffed over there with all of the courthouse deputies to make sure people are going to be safe that have to use the courthouse. Now, one of the things that we did early on, because the chief judge was really good about this, she was very concerned about the health and the safety of the people coming to court, not to mention the employees. I was able to get some technology where I can screen all of the employees that come into the courthouse, and I can screen all of the participants that have to show up for court. I have a system where I can monitor the temperature of people coming in. And if we see somebody that's got a temperature of 100.4 or above, we will actually pull them out of line, use the forehead thermometer to verify that. And if they are symptomatic, then they're not going to be allowed to enter the courthouse. So that was an extra precaution to make sure that anybody that's coming to court is going to be symptom-free or not showing any symptoms of having the virus, and that the employees are going to be screened to make sure that it's safe. So it's working out real well. There was some talk about doing self-screening, but I'm not a big fan of that. I lost your sound.
Your It
So
looks like, yeah,
at the end of the day, we're really happy about the way the courthouse is operating. The chief, like I said, the chief judge has done a great job as far as making sure that the courtrooms are operational and people are going to first appearances and that everybody's safe in there. We've taken a lot of precautions. So we're doing the best we can to make sure that the criminal justice system is going to operate and function the way that it should under these difficult times.
thank you, Sheriff Bradshaw. Really quick, may I ask all of our panelists to mute your phones when you're not talking, just so that we can eliminate any background noise? We're getting some messages via chat that we are getting some background noise. So if I ask you your question, then please just unmute yourself and answer. Also for our participants, our attendees, we do have a chat feature on Zoom and a question and answer feature, so please feel free to use both if you get any messages. Judge Marks, it looks like you are joining us. Are you able to hear us?
I can hear you.
Okay. We are getting some pretty bad feedback on your end. Are you connected via both the computer and the phone? If so, you need to hang up on one of them.
Jessica, can you hear me?
I can hear you. Keep speaking because you had some feedback.
All right, let me just appear via phone then.
Oh, no, that works. You're working. I'd stay. All right. Well, let's keep moving. Again, thank you, Sheriff Bradshaw, for answering both of those questions. We do have a few more for you. If you're able to stay with us, we will circle back to you shortly.
No problem.
And then if you, again, like I said, if you can now mute yourself while I move over to Ron Ponzoli. So Ron.
Jessica, can you hear me?
Yes, I can.
Them now.
You sound okay. Can you introduce yourself really quickly to everyone, just so we can hear how your audio sounds? Judge Marks.
Welcome to Zoom. Enter your meeting ID.
Okay. He's still trying to get connected. So, Ron, let's see if we can get some questions to you.
Yeah.
Okay.
Webinar going. So, a question came in, Ron. How do I know what qualifies as an essential service under the governor's Safer at Home order? And how do I know legal services are essential services?
Sure. Well, thank you, Jessica. So the
You entered 312626. You have not entered any numbers. Please re-enter your meet.
For those of you who've seen the governor's Safer at Home order, you may have also seen that there is an essential service list. There's actually a master list that attaches to the order, and it's a great cheat sheet for everyone if you want to take a really deep dive into all of the various components of what is an essential service. I think it's safe to say, everyone, that as we move as a community and as a state through the pandemic, and as we sort of watch the change or the effort to reopen the state, I think we're going to see some changes in what is an essential service. But for present time, there is a master sheet. I would encourage everyone to look at it for some of the finer details. But for those of us, the practitioners, the lawyers, first off, the Florida Bar early on, and when I say early on, I mean in late March, took the position that the Board of Governors took the position that lawyers, the practice of law was an essential service. It is the position of the Florida Bar. The Florida Bar and the Board of Governors have written to the governor and said as much. And then when the governor's Safer at Home order came out, there's really two portions that we look at to comfortably say that our profession, the practice of law, is an essential service. There's language, and if you all remember the evolution of the Safer at Home order, it evolved out of Miami-Dade's Safer at Home order, and the Miami-Dade Safer at Home order had language that appears in this master list that says essential services include professional services such as legal or accounting services, when necessary to assist in compliance with legally mandated activities. And the bar has taken the position that naturally encompasses the practice of law. And interestingly, there's also language in the master list that identifies workers supporting the operations of the judicial system. Well, we're all officers of the court, the members of the bar, so that language naturally supports the practice of law being essential service. We have not seen, the Florida Bar, the Board of Governors, we have not seen instances where attorneys have been turned away, told to go home, told not to go to their offices when necessary. But I will reiterate President Stewart's and the Board of Governors and the bar's position. It continues to be important that when we can, that we do stay home, that we do exercise social distancing, that we do work remotely, that we do encourage and allow our attorneys and our staff members to work remotely. But in terms of our ability to come to our offices and work in our offices, it is, as far as we're concerned, very clear that this is an essential service, and the master sheet says as much. So that's how we answer that question, Jessica.
Okay, great. One more question from you, Ron. This one comes from Eddie. Eddie wants to know, what can seasoned attorneys who are up and running do for other attorneys in this time of need?
Yeah, well, Eddie, thank you for that question, and it's awesome, by the way, to see how members of the bar are reaching out across the board to help other members of the bar and the members of their community. There is it's called Lawyers Advising Lawyers, and it's a service that the Florida Bar provides, and it's a very easy service to become a part of. You go online and through the Florida Bar site, and if you have 5 years in a particular area of practice of law, you essentially become like a mentor to members of the bar. And I can assure you all that we are going to, as a community of attorneys, we're going to have attorneys who are going to need more than ever before the ability to reach out to other colleagues, ask questions, have resources available. So I think a great opportunity exists for our colleagues in the bar to become part of Lawyers Assisting Lawyers Now and be that resource for when a colleague needs a question answered, and have your expertise available to another member of the bar. So that I would strongly encourage that you take advantage of that. And the other thing I would say is the Florida Bar is putting out a tremendous amount of information about COVID-19 and how it's affecting the practice. There's a dedicated webpage for COVID-19. The Supreme Court orders are coming out. The court orders are coming out. That's all available there. But what's also available there, what's available through the bar, there's a whole lot of webinars that are now accessible specific to COVID-19. There's a webinar about the CARES Act. There's actually a chapter 2 the bar is going to put out, the second part of the CARES Act. There's how to practice remotely. And what I would encourage all of those who are participating in this webinar to do as an extension of how to help your colleagues, let people know that the bar has resources available. Let people know that Legal Fuel, which is a tremendous resource for webinars and CLEs, has specific targeted information right now about COVID-19 and how to practice during the pandemic. Spread that news through your law firm, spread that news through your colleagues, and I'm sure someone who doesn't know that resource is available will pick up on that resource and you'll be helping them. So I would encourage that as well.
Okay, thank you, Ron. So welcome, Judge Marks. It looks like you were able to get connected.
I took the whole IT team. I don't know what happened. We Zoom every single day in here, and we've never had this problem ever. So I apologize.
Well, no, thank you. We're glad you kept trying because we got you now. So that is terrific. I will quickly ask you a couple of questions, and for everyone, I'm sure everyone on this in this webinar knows, but this is Chief Judge KRISTA Marks of the 15th Judicial Circuit. So Judge Marks, can you tell us, and be as descriptive as you want or as simple as you want, but what hearings are currently being conducted at the courthouse or virtually?
And that has changed as we've tried to adapt to the Supreme Court AOs. So we frankly have gotten much stricter with regard to those hearings that can be conducted face to face. There's a very distinct list of exactly what can be conducted face-to-face, and those are referred to as essential hearings. When we first started off, I was giving individual judges the discretion to add on face-to-face hearings, but that frankly ran awry. And, there were 40 people in a courtroom at any given time. So with this latest iteration of the Supreme Court AO, we have really streamlined what we're conducting face-to-face. And all of those are listed on the administrative order. It's basically bond hearings, detention and shelter hearings, Baker Acts and Marchman Acts, those kind of things that are urgent and for constitutional reasons have to be face-to-face. I really want there to be a clear message to the bar that any hearing that you could possibly want to schedule, which we refer to as non-essential hearings, we have the capacity to do it. I mean, I'm hoping it's better than the Zoom that we got that we started with here this morning, but we've got a great IT team. I have no idea what happened with regard to this meeting, but we have judges conducting even evidentiary hearings that are non-essential hearings. You've got to get the evidence to the judge and to the other side. So when you're referring to a particular exhibit, everybody's on the same page. But I know that in family court and in circuit civil, even evidentiary hearings are being conducted via Zoom. So we really want to send the message that we're willing, ready, and able to schedule all your hearings. There will be no judge who will tell you, I'm not scheduling hearings. Now, whether every judge feels adept enough to do a non-jury trial, that remains to be seen. I have to tell you that most of the judges are indicating that they're opening up their online scheduling and that there's just no takers. Perhaps that's because people were confused and they were thinking that the judges weren't scheduling non-essential hearings, but that is not the case. And so the clearest message I want to send today is that the judges of the 15th want to hear your matters. We encourage you to do so because we feel like when this lifts, we're going to be flooded with business. So, if you want your motions heard, I don't understand why people aren't taking advantage of all of the open spaces. If you just go to each judge's divisional instructions, you'll see there's tons and tons of time available for you to schedule your matters. So I hope people will start taking advantage of that.
And it could just be that with so many orders coming out, people are confused. So perhaps as a bar, we can do a better job of trying to update our members so that they are aware of those options available to them. So you touched on this. Are some of the judges doing criminal or civil trials right now, non-jury trials?
Well, they are not doing it in criminal because criminal is just a lot more complicated with regard to the constitutional right to confrontation and having to, in civil, there have been non-jury trials in both family and in circuit civil. So not in county court, but as I said, there's evidentiary matters that are being scheduled. So if you've got a short non-jury or a non-jury family matter, I know that judges have been conducting those.
Okay. Well, we have a question from Michael who asks, and there's multiple parts, so I'll try to get as much in as possible. But Michael would like to know, when realistically do you foresee the courthouse being open again for regular business? And in that same note, criminal trials starting again? And then that part first, and then I'll do the last part.
Okay. Starting next Friday, the administrative orders for quite some time, every iteration of it has said that through the end of May 1st being the last Friday, we have really scaled back to just the bare minimum essential hearings that must be conducted on a daily basis. So starting the first week of May, with the first Friday being May 8th, the courthouse will be open for all intents and purposes Monday through Friday. So I eliminated Fridays or scaled them way back just to reduce 20% weekly of people being exposed or coming into the courthouse. So we are stepping back in, and that will be the first thing we do is Fridays will be back in play. The most recent Supreme Court AO told speedy trial and getting jurors or grand jurors in here until May 29th. So with, unless we hear from the Supreme Court that that's been extended, then I actually spoke with the clerk's office at a meeting yesterday. So we are all anticipating that first week in June is when summons will go out. you know, I know you've heard me say it at meetings before that when we have to send out 1,000 summons to get 300 jurors on a regular day pre-pandemic. So we only have about a 30% yield. And so I can only imagine how very, very difficult it is going to be for us to get jurors in here when we start rolling back into business. And, you know, so we're already trying to research ways of how we're going to address speedy trial issues and things of that matter. But as it stands right now, I anticipate in June is when we're going to start trying to get jurors in here, with criminal being the priority and of course speedy trials being the next priority.
Got it. We have some questions coming in from our attendees, which I'd like to get to, but really quick before I do that, Judge Marks, if you could mute your phone, I'm going to ask a couple questions of Cindy. So Cindy, if you can unmute. Cindy, can you hear me? We need you to unmute when you can. We still can't hear you, Cindy.
Okay.
There you are. And
All right.
now she's okay. Can you hear us, Cindy?
I can.
Okay, great. So Cindy,
Can you?
which clerk services are available either electronically or in person right now?
All services are available electronic, and we are open to the public for some limited services. But for the most part, you can, or for all parts, you can do everything you used to do. You just may do it a little differently, either electronically, by mail, or like I said, in some limited cases, you can walk in. We do have a drop box at the main courthouse in the lobby where you can drop some pleadings and recordings. So everything is open electronically. You can mail in things. We know lawyers are mailing in their wills and some of the guardianship documents via trackable mail like FedEx. So it's business as usual for us.
Terrific. Another question for you is, what is the status of foreclosure cases right now?
We, the foreclosure cases that come in, but there is an executive order, and so that's all we do. If you file it, we're going to docket it, but that's all we're going to do. We're doing nothing else. And so I'm not sure that people should be filing foreclosures right now, but that's not for me to say. I think I would read the executive order before filing a foreclosure.
Right. Same thing with evictions. How are those currently being handled by the clerk's office?
Those are a little bit different in that we are docketing them and we are issuing summonses. We don't have authority not to issue a summons. So we are doing, we're doing our work. Now we understand that, and Judge Marks could probably speak better to this, that there's not going to be any final judgments entered, but we are processing all evictions up until clerk default.
Okay. And one of our attendees, Peter has asked, what about marriage license? Are you guys still processing those?
Peter, thank you for asking that question. We are processing marriage licenses in all branches. So you can get a marriage license in person at North Branch, South Branch, West Branch, not at Main. And we're trying to reduce the traffic at Main. But the exciting part is, and you do need an appointment because we're trying to limit the number of people that are coming into the lobbies. But the exciting part is that we're one of the first clerk's offices in the country to issue a marriage license electronically. And we did that on Monday. So that's another option.
Okay, thank you. Cindy, I'm going to have you mute yourself now. And Sheriff Bradshaw, could you unmute yourself? I'm going to direct some of these attendee questions to you.
I think I did it.
Yes, you did. Thank
Okay.
you. So one of the questions, I think it touches on what you mentioned earlier about changes at the jail with visitors, but a specific question came in from Michael asking, when attorneys come to the jail to see their clients, is there anything being done differently that they should be aware of before they come in? And
Well, the regular visitation is all video visitation. Nobody goes in there to visit unless they're an attorney that really wants to go in. We can do secure video for them if they really want that. But if there's some reason that they're going to have to basically be in there, then we're going to ask them to mask up, glove up, and we'll provide them a secure area. And then the inmate will also be masked and gloved up. And of course, the defense attorney will probably get their temperature taken before they go in there to make sure that they're not active. But we'll make it a safe environment for them if in fact they have to do that.
Okay, thank you. Let me see if there's any other questions that have come in for you. So, what changes on the law enforcement side of things has the sheriff's office made in response to this pandemic, and what enforcement actions are you guys taking with regards to the state and local orders that have been issued?
Well, obviously, there's been a lot of changes just in the basic operation every day. The communications people ask a lot more questions of the people that call in. So if we really don't have to enter the residence and talk to the people, we're asking them to come outside where we can put some distance in between ourselves and other people out in the outdoor area out there. If we have to go in, then the questions that the dispatchers are asking is there anybody sick in the house? Have you been sick? Those type of things. But if we have to go in, then all the deputies are fully prepared with all the personal protection equipment. We've had that early on. So we're taking all the enforcement action that we have to take on a regular basis. We are issuing a lot of notice to appears, NTAs, on very minor violations, most of which we do anyhow, but we're being a little bit more cautious on some of the violations that we may have brought to the jail. We're doing NTAs for those. But basically, everything is operational. And as far as the enforcement action, I mean, there's a lot of things that are in these orders that are, kind of gray. We've walked very softly. Most people have complied with a warning. And for the most part, the people in Palm Beach County have been good at doing what they needed to do because it's in their own best interest so they don't get sick. So we've seen a lot of good compliance, but we're being very, very cautious about a lot of warnings and everything. If we get somebody that just is not going to comply, with a business staying open that shouldn't be open, then we'll take the enforcement action we have to take. If we have some quarantine orders by the health department and they violate the quarantine, that's a misdemeanor, and we can take them into custody. And I think the chief judge has addressed that particular issue in one of her executive orders.
Thank you. I have one final question for you, and then we'll see if we get any more panelist questions later. But what do you see law enforcement's role being when businesses and public spaces do reopen? Do you see there being a role different than what you had before?
No, it's basically going to be, making sure that people are going to comply the right way and see what the parameters are going to be. But at some point in time here, things are going to have to get back open, and there's going to have to be some parameters, kind of like what you see at Home Depot or Costco, where you have a certain amount of people outside. They have some distance in between them because there's marks on the sidewalk. Somebody's counting the people coming in and out. There's a mandatory mask if you have to go in. So it'll be those type of things, but it's probably going to be, we're not going to have deputies checking every single business every single day. It's probably going to have to be one of those see something, say something. If somebody makes a complaint, then the deputy will go and make sure that everybody's in compliance. But again, it's in everybody's personal and business best interest to go along with what the guidelines are so we can get the economy back open and everybody can get back to normal, or some semblance to normal. I'm not so sure there is a new normal anymore.
I would tend to agree with you. I don't know what the new normal will look like,
Yeah.
but I do think it will be a new normal. Thank you, Sheriff Bradshaw. If we have any more questions, I will circle back to you, but for now you can mute again, please. And I will go back to Ron.
Okay.
Let's see. Another Michael, we have a lot of Michaels on our in our attendees today, asked you to remind practitioners that the real property, probate, and trust law section has valuable information for practitioners at reptile.org. You can also click on the COVID-19 icon. Do you want to talk a little bit more about that and what the other sections might be doing, or resources that people can turn to for information?
Well, yeah, thank you for that question. Again, the Florida Bar with this dedicated webpage has tremendous resource. Some of the sections do have their own resource as well. I think a great starting off point for folks is the Florida Bar webpage, and you will see President Stewart's messages to the bar. Again, court orders. You'll be able to find various webinars that the bar is making available, and section information as well. So again, I think that the point is that remind folks, your colleagues in the bar, that the bar has this resource. Go to the webpage, go to the sections pages, and just about everyone is talking about how to practice in this new state of things and how to navigate through the issues we're all encountering as a bar.
Thank you. Another question we have is, and I'm assuming this is in the context of the Florida Bar, but how is the governor's safer at home order enforced, as far as you're aware?
I think Sheriff Ric Bradshaw just gave us a pretty good idea about that. I believe violations are second-degree misdemeanors, but that's really my understanding. I think the sheriff gave us a pretty good understanding of how that works out in the field.
I agree. So do you know if we need special permits to leave our house if we're going to an essential business?
We do not, but there is a suggestion that has circulated, which is if you're an employer, there may be wisdom in having your employees have a letter that sort of speaks about what they do. You know, I'm a paralegal in the firm of such and such and such and such, just so if there is an issue about where someone is, and whether they truly fall within an essential service, having that piece of paper may help them navigate through. And again, I think Sheriff Bradshaw gave us a pretty good idea that warnings are usually the means of getting folks out of situations they're not supposed to be in. But I think that if you have an essential service, you don't need any sort of special permit. And again, the bar has not seen instances where attorneys, members of the legal profession, have been prohibited from practicing, from going to their offices when necessary. But again, and I echo Sheriff Bradshaw's comments, the bar's position is if you can work remotely, it's better to do so now, and to follow the practices that we're hearing from the CDC, and to avoid as much contact with others as possible until we hear otherwise.
Thank you. I think this is a very relevant question, especially right now when many of us are wondering how we're going to continue to do this work from home thing. If you need counseling concerning COVID-19 or maybe even any other issues, can you receive it from the state or the Florida Bar?
Yeah, well, thank you, Jessica. That's a great question, and I'm very pleased to let everyone on the phone know, and this is a product of the Florida Bar's Health and Wellness Committee, that beginning May 1, so just around the corner, the Florida Bar is going to launch a resource that is now available to practitioners of free counseling. And that's not just mental health counseling, that's financial consultant counseling, even case manager to help find long-term facilities for family members. And I'm going to give you, those of you who have a pen handy, and I bet a bunch of people on the phone do, the number is 833-351-9355. 833-351-9355. And what is this? This is a resource that the bar is now making available to practitioners, where you can have a three free consultations with a health care provider, or rather a mental health care provider, on issues of whatever one might be encountering. Right now, well, I say right now, come May 1, these will probably be remote consultations. But this is a tremendous resource that the bar is making available to the practitioners. And I think now more than ever, as we continue in what our new normal is, there are new stressors. I know I have them in my practice. I suspect everyone on the phone and everyone who's participating now has new stressors. And when those stressors come into our lives, having a helpline available to us is tremendous. So I would encourage everyone on the phone to have that number available. And if you need it, it's there for you. And I can't hear you, Jessica, but I don't know if that's just me.
Nope, I had muted myself. I'm going to have you mute yourself now, and I'm going to turn to
Thank you.
Chief Judge Marks, if you could please unmute. Okay.
I'm in.
Thank you. So we are getting a lot of questions for you. Let's see. Do you know when jury trials restart, will there be masks and social distancing requirements for jurors as far as you're aware so far?
Yeah, and I don't think that's going to be any problem, which goes back to what I said before. Good luck to us getting jurors in here. We all know it was a huge problem before this even started. So, you know, any ideas you come up with how we can increase yield when we start calling jurors back in, but I think we'll have lots of opportunity to keep everybody 6 feet apart.
That's great. So we have Michelle and Richard, and we have, let's see, another Richard on the question and answer area of this program, all asking about the video hearings. Is there one particular platform all of the judges are using? Is it Zoom? Is it something else? And how is that going so far? It sounds like you said better than what happened with this webinar, but maybe you can go into that a little bit more.
Listen, Zoom has been working terrific for us. We had a hard time getting it because there was such a worldwide cry for it. And so we started off with WebEx. And now, you know, we have the professional version of Zoom. So you're not knocked off after 40 minutes. You have the recording capability. There's just so much more that comes with that platform. So with regard to UMCs, for example, each judge has Zoom and has Zoom training. And to me, it makes more sense that the judge would host the UMCs and that information would be provided to everybody who has a hearing that day. But there are people out there who aren't Zoom trained or don't want to do it. And so we still have 3 listed vendors for call. I don't have the 3, but they're on each and every divisional website for the individual judges, as well as our 15th website. So some judges might prefer that the attorneys arrange for whatever platform they want for the hearing. But I think as we move along, people are going to get more accustomed to using Zoom, and that certainly when the judges host, Zoom will be the platform that we use. Just so everyone knows, not that we're endorsing any particular vendor over another, because we are not.
Thank you. So it sounds like what the answer is Zoom is probably the way of the future, but right now there's multiple options and it really depends on the division and on the participants.
Right, and there's 54 judges and they all have their different ways of doing things. So, you know, if there are attorneys in civil who prefer another vendor or another platform and they want to set the meeting up rather than the judge setting it up, then they can use whatever they choose.
And so also then it depends on the division whether the judge is setting up the virtual hearing or whether the attorneys are setting that up. It just, everything's going to be division by division?
Pretty much, but it'll be on their divisional instructions. So it shouldn't be confusing at all. So if you have a hearing and in front of any particular judge, you'll simply go to their divisional instructions. As I said, on those larger dockets like UMCs, I think you're going to see that almost everybody's going to use Zoom rather than hanging up and now I'm going to get a telephone call from these people and now I'm going to go back to Zoom. It will just lend more consistency to be doing those larger dockets on one platform.
And how are you seeing the judges, what's the judges' preferences on how you submit the evidence for hearing? And do you know of any judges that are having webinars or other instruction instruction type materials given to attorneys on how they're handling that piece of evidence, submitting it, introducing it, etc.?
I think what I can say generally is this: we want to keep the judicial workflow going as best as we can while keeping everybody safe. So we've been having meetings all week long for how we can do that. So people have been resistant to the evidentiary hearings because it's just so much more difficult. But what is going to generally happen is prior to that hearing, you will have scanned and sent copies to opposing counsel, and scanned and sent copies to the judge. So almost everybody's going to do it that way, and you'll have them pre-marked, and then everybody will be on the same page. So when you're conducting the hearing and you're referring to Exhibit 3, everybody will just be able to pull it up. You know, there's also the option of pulling it up on the split screen with Zoom. So you can split your screen and say, just so there's no confusion, here's what Exhibit 3 is, and whoever's introducing it will be able to use that as a good option as well.
Okay, so Cyrus asks, are they printing the evidence for submission to the clerk once it's been submitted electronically?
Well, that again will depend on each judge and what the particular piece of evidence is, because we're trying to e-file everything. We know that it's an electronic world, and that's the good part about this. We're all going to be so much more adept at electronically filing and using these kind of venues and not convening groups of 30 when you can easily do it via Zoom. So that's the sunny side of what's going on here. People who were tech phobic are having to get with it. So I think, you know, a lot of times that will be submitted electronically to the clerk, because the clerk doesn't want all that paper and all that evidence anymore. So depending what it is, you know,
right.
In criminal cases, guns will still have to be given to the clerk, that sort of thing. But I think mostly you'll just be seeing that it's electronically submitted to the clerk.
Yes. Rhonda asks, is there a specific procedure for documents that need to be sent for in-camera inspection right now?
Again, they would just be scanned and sent to the judge for an in-camera inspection.
Okay. Let's see, we have so many more questions for you. So I think this is a good question. Trace asks, depending on the success of video conferencing platforms for these judicial proceedings now, has there been any thought or discussions about possibly using these platforms in the future, even when the courts are fully reopened to the public?
I think we're going to definitely see that. I think that people will find that it's more convenient to just do it from their own offices, particularly hearings that aren't lengthy. I mean, I still think for some time there'll be resistance with regard to evidentiary hearings. Certainly the availability of not having to fly an expert down. I think we're going to see a lot more use of this as things calm down.
That's great.
We actually got a new administrative order about a task force that's getting together to decide how we're going to incrementally step back into regular business. And that is one of the recommendations that they'll be making post-pandemic. How can we continue to use electronic means of conducting hearings and, you know, put that into best practices?
Exactly. Has there been any discussion? Apparently in Broward, there is a judge that is trying to conduct a jury trial via Zoom or some other format. Have we discussed doing any of that yet?
No. Good luck. Good luck, Broward. I don't know. I guess, you know, maybe we'll get there. I'm hoping we'll be pulling out of this before we have to start thinking about, you know, we've got till the end of May before we even have to start thinking about jurors. And I'm trying not to keep that at the front of the burner because it's going to be perhaps one of the most challenging things yet.
Yes. So I'm not sure if you'll have since this isn't your division, but there's a question from Joel that asks about the family law division. And I guess there's a little inconsistency on whether the hearings are moving forward via Zoom or not. And he asks, is there anything that can be done to avoid automatic cancellation of hearings and trials in that division that had already been set, or that they can anything that they can do to try to get one set where it's possibly a sensitive issue that needs to be resolved?
I think that's a great question. And listen, family is a division that so many matters are time sensitive and time urgent and can be even dangerous. So I talk to the family judges all the time, and they are trying to address that as well, because there's a lot of people who just haven't acclimated to this idea of appearing via Zoom. I think there's a lot of attorneys out there who feel like, I want to be there face to face so I can convince the judge that I'm right. And so we're getting a lot of resistance. Like I said, there's online scheduling that's wide open, and we're having a hard time filling it. But we have been addressing that you don't get a choice right now. So if a hearing is scheduled for a Zoom meeting or whatever it is, one side, the family judges have been telling me this. One side will call and say, I'm not coming. So what the attorney who says that can expect to hear is, we'll be moving forward without you then. You're making the choice to not appear, and you're not going to unilaterally cancel the hearing. So I would encourage all family practitioners, all practitioners, schedule the hearings. The judges will not be there. You no longer have to see if that's fine with both sides, if both sides agree to appear electronically, because the AOs say that this is how we're proceeding during this pandemic. And if you choose not to come, then the judge will make the decision based on what they hear.
Oh, great. And all the scheduling is being done online right now, correct?
Correct. We're for civil and family. That's not true for criminal. Criminal, the JAs are setting.
Okay, that's good.
Juvenile, the JAs are setting.
So Peter asks, first of all, he says, thank you, Judge Marks, for all you are doing to keep the practice of law continuing for our clients.
Thank you, Peter.
Some positive statements. His question is, the most recent admin order has been interpreted by some folks to not address depositions and discovery outside of actual court proceedings. What is your perspective when a party insists an in-person deposition or discovery production is needed? Could this pause a case? In theory, could this pause a case until a vaccine is readily available? What are your thoughts on that?
I think you need to set that on the judge's motion, and the judge will be ordering that the deposition move forward electronically. So I think that's, it's a rare situation, I think, where you'd be able to convince a judge that it needs to be face-to-face. All of the administrative orders of how courts are to be conducted say that we should be minimizing face-to-face contact as much as possible. So I think you should get it on the judge's docket for a motion if you've got one side that's insisting, I'm not going to do any depots or any discovery until this lifts, because we don't know when that's going to be.
Right.
I think most judges will order that it move forward via Zoom.
And the same, if they're insisting on an in-person one, again, that's something the judge can decide if it needs to be in person or can be conducted via Zoom or some other method.
Yes.
Okay. Michelle asks notes that she would like to attend a remote evidentiary hearing as an observer so that she can learn and see how the process goes. Are there any judges that might be amenable to such attendance? And then do you know which judges in particular are actually holding remote evidentiary hearings? It was a two-parter.
Well, access is an issue that we have continued to, it's been evolving as we've been bumping along, but I want everybody to know this, because sometimes, although we're limiting who can come to the hearings, any hearing that anyone wants to attend on whatever platform, if they simply call our public information officer, they will be given the Zoom meeting number and the password, and the judge will be able to mute those people that are voyeurs or that are there just to watch. But we are providing access to each and every hearing that we have scheduled. So you can either, from your colleagues, if you're trying to use it as a tutorial, find out when they have hearings, or you'll be able to access that. You'll know that every morning UMCs are being handled, and we welcome that. I mean, it might be a good learning opportunity for people that are at home to be able to sit in and watch more experienced lawyers conducting some hearings. So you can get access to each and every hearing, whether it is face-to-face or a non-essential that's being conducted remotely. We will get you access.
I'm going to ask one last question about these Zoom hearings, and then I'm going to open this back up to both you and Sheriff Bradshaw. There's a question directed to both of you, but for you right now, Judge Marks, is there a particular form of notice of hearing for the Zoom hearings that the court is requesting that the parties use, especially when you have a pro se litigant on the other side?
Well, if it's a Zoom hearing that the judge is conducting, the judge will be the host. So when the hearing is scheduled, the meeting number as well as the password will be provided to the parties. The parties can feel free to share that with whomever they want. It'll also be sent to the pro se individual. And as we all know, if you can't access the video, you can at least call in on the toll-free line. So, and again, those will be able to be accessed by any member of the public who wishes to not participate, but to observe.
And so if the judge is setting the hearing and therefore providing the dial-in or online access information, are they doing that in an actual order setting the hearing, or is it just simply an email?
Well, that's going to vary. I mean, because we've only been using Zoom for a couple of weeks, but I am leaving a lot of discretion to the judges because that's how they like it. So, you know, for the most part, when your hearing is scheduled by the judicial assistant will tell you, we'll follow up with the information regarding the dial-in.
And so if someone—
And that will also be provided to our PIO for anybody for access purposes.
And so it will probably depend on the division if the judge will ask the attorneys to issue a written notice of, well, an online or electronic notice of hearing that then also includes that information so that the other parties get it. I'm assuming this will probably be all division by division and what the preference is.
Well, and there might be some judges who leave it to the attorneys to decide what platform to use. And in those instances, whatever the attorneys agree upon will be provided to the judge. So, you know, whatever it is, if the attorneys are planning it, they'll be the ones who give the judge the, you know, whether it's court call or whatever, the judge won't be hosting versus the Zoom hearings, which the judge is the host on. The judge, the JA, will be responsible for making sure people have the pertinent information.
Okay, I actually have one last question because it's an easy one. Are the court Zoom hearings being recorded?
It depends if they have to be recorded. So say you're in county civil and none of those hearings are recorded, the judge has the option of recording it or not. Some of our hearings must be recorded, and by statute, we're the keeper of the record. So in those instances, I'm asking that the judges on hearings where we're the keeper of the record, that they conduct it in court, because I don't have complete confidence that Zoom and the cloud have all the worldwide hearings perfectly ready to be transcribed. So we like the backup of our recording system within the courtrooms for hearings that must be recorded. But when it's optional, that'll be up to the judge whether the hearing will be recorded or not.
Okay. Sheriff Bradshaw, if I can have you unmute your phone now or your computer.
Okay.
Thank you.
And before I go to, can I just give the sheriff a big shout out? I don't know how many of you have been into the courthouse and seen the temperature machines, which are just unbelievable. And I know the sheriff talked about it briefly at the beginning of the meeting, but you know, within hours of me expressing a concern about the public part of the individuals that are coming in, I mean, the sheriff worked so hard at this, and these machines were wildly expensive, and neither one of us believe that they're foolproof, but we will be using them for many, many months to come. And the entire 15th, and I hope all of you just have unbelievable gratitude to Sheriff Ric Bradshaw for getting us that extra measure of protection.
Thank you, Judge.
Yeah, I can see them coming in handy during flu season every year too. Okay, so I have to ask this question first of Judge Marks. What is a CPT examination? Because that's what this question is about, and I have to admit, I don't know what that is. I don't know.
What is a what?
A CPT examination. Do you know?
I don't know. I don't know. Is that a probate examination when they're trying to determine competency? Is that a competency physical test?
Okay.
I haven't been in probate in a while. Somehow everybody thinks the chief knows everything about everything. I guess, is it a probate question?
It's a juvenile question. I just got the attendee clarified. It's a child protection team exam in juvenile. And they were asking to both of you, Judge Marks and Sheriff Bradshaw, what, do you have any new information on how they're being conducted in Palm Beach County? Apparently there was a news story yesterday saying at least 34 were not performed in March, although I don't think any of us knew what was really happening with all of this in March. But is there any information on how those child protection team exams are moving forward?
Well, you know, it's my understanding that let's say we have a call that goes into the Division of Youth Services through the state, that there's a problem in a household with a juvenile in the household, and they need to go there to perform the examinations. Usually they would call the sheriff's office, and a deputy would accompany them there from our particular perspective. So if we get that call, we go. So it would be incumbent upon the people from Division of Youth Services to perform the examination. I don't think it's a court thing. I think it's, unless I'm reading it wrong, it's Division of Youth Services through the state.
Okay. If there's any follow-up on that, I will be sure to direct it to you guys. But
Yeah, but we would not turn that down. We would go there to do whatever their normal examinations would be.
thank you. I'm going to look through here to see if we have any more directly for you, Sheriff Bradshaw. We've got a lot of questions.
The best thing for everybody to know is we're doing business as normal. I mean, this has not stopped us from doing anything. The deputies have all the personal protection that they need to accomplish whatever they need to accomplish. All right. So, I mean, I've had people call and say, you think the people are going to do more break-ins? You think that the bad guys are going to think that they got to, you know, we're not going to be out in the same numbers that we're out there. We're fully staffed. We're ready to go, and we're going to be there just as we were in any other disaster that's out here. We're going to be there doing what we need to do. It's just that plain and simple.
Good. Okay, so the follow-up question on that child protection team exam was that it's their understanding that the CPT members that are performing the exam, especially where it calls for a physical exam, are refusing to do those exams in person. Are you aware of that and have any comment on that?
No, that wouldn't be us anyhow.
And Judge Marks, there's nothing that you would have to add to that from the court?
Well, there is, because that's something that's happening not just in juvenile, but in probate as well, with regard to incompetency and emergency hearings on competency, where an exam has to be conducted by a physician. So I can tell you that the physicians, and we have a certain list of people who can do it, are not conducting those physical exams, which doesn't meet the statutory requirements for making the determination that the person is incompetent. So, you know, and I know DJJ is in my administrative order for some of these face-to-face meetings that they have with juveniles and the family of juveniles, particularly in dependency matters, that those are not necessarily being conducted face-to-face. It is far from ideal, but some of those are having to be pushed off because, you know, we can't force the doctors to go to the location. A lot of times they can't even get into the nursing home, for example, in the probate arena to conduct the exam. So it's a problem. It definitely is. But same for DJJ, the Department of Juvenile Justice. They've requested that they be permitted to do some of the check-ins with the families remotely. And that's where we are now on it.
Okay. Judge Marks, how are the courts swearing in witnesses when they're doing these Zoom webinars? Is it just as long as they can see the witness and see that they're, you know?
Well, you can see from the administrative orders right out of the Supreme Court that the rules for swearing in and the requirements for notaries and so forth has been quite loosened, and that is in the administrative order. We have that in our local administrative order as well. So it is much more relaxed. There's all sorts of stuff that we're doing that is troublesome, but at least from the 15th, from my perspective, I am not entering anything in the administrative order that flouts a statute or a rule because I don't have the authority to do that. Oddly enough, I've seen it done throughout the state in different arenas, but I am doing my darndest not to enter any administrative order. So there's still stuff that gives me pause, though, that we're doing. For example, not having DJJ have face-to-face meetings in, situations like that where there could be some danger, but we're just doing the best we can. And so with regard to oaths and notaries, will that become an issue? I don't know. I mean, it came from the Chief Justice, though. We didn't make it up. So we'll see if people challenge the Chief Justice's authority to do those kind of expansions. I expect there'll be litigation
Right.
on
And
all
that's,
sorts of different fronts.
that's actually a question we received from several attendees in different formats of the question being asked, but essentially, what can attorneys do to preserve their objections, whether it's to the actual conduction of a Zoom hearing, whether it's to these different, loosening of the rules for witnesses or notaries or anything that could be happening that's different from how it used to be? What's the best way that they can preserve their objections and make those objections?
I mean, just like in any situation, they've got to preserve the record. With regard to, I know this, you don't get to object to the non-essentials being conducted remotely, and that comes from the Chief Justice of our Supreme Court. So when you're taking that issue up on appeal, good luck. Because, that's what the Chief Justice said that we're going to do at this time. I think, it's a much richer ground for appellate argument when perhaps some of the chief judges around the state are not lockstep with what the Chief Justice has said, or when they're putting something in their administrative order that is in contravention of a statute or rule. I think you'll be on much greater footing. But when it comes from the Supreme Court, certainly that challenge can be made, but you have to look at where the authority came from to make a decision of how great your appellate chances are going to be.
Right. Okay, thank you. I am going to move back to Cindy if she's still with us. Hi, Cindy. If you share, Bradshaw,
I'm still here.
you guys can mute everyone else. There we go. Cindy, a question came through. If a fee needs to be paid to the clerk's office, are you guys accepting those only via check? I don't know if it was in, let me try to find the question because it was
I think it was regarding copies. Bradley, I think, asked a question about copies, and I answered him to give me a call, but I will tell you, you can mail it in. Most payments for traffic and can be made electronically or by telephone. Marriage licenses can be paid by electronically in an app called Pay It, that if you go to our website, you can get the information. We are getting an extraordinary amount of payments made electronically by phone also in single days. So those methods are available. And for all information, visit our website, mypalmbeachclerk.com. But also, I urge attorneys to, instead of calling us, send us an email at clerkweb@mypalmbeachclerk.com, because we're answering those almost same time, and it's a lot quicker to get lawyers' answers almost same time rather than calling our line. You can't imagine the number of calls we're getting on a daily basis, a few thousand a week. So our call center is bogged down, and I don't want attorneys and their staff to get stuck on wait calls. So just send us a quick email, clerkweb@mypalmbeachclerk, and we will answer almost same time.
okay. Thank you, Cindy. And I think you answered both of these remaining questions I have for you earlier, but just to make sure we've got them addressed. Documents can still be recorded right now, right? And if you have
Absolutely.
a document, and if you have a document that can't be e-filed, the current procedure is to send it via trackable delivery somehow.
Yes, two methods. Trackable delivery is perfectly safe, and we're getting that from attorneys every day. But also we have a drop box in the main lobby of the main courthouse. And as far as recording, you can record electronically. We have a spike in electronic recording. As Chief Judge says, the sunny side of this whole thing is that I think people who maybe were not on electronic are now jumping on the bandwagon and getting with us. And so electronic, there's a small fee, but if you don't want to pay the small fee, you can mail it in.
Okay. And one last time, can you give that email address for the clerk again?
clerkweb@mypalmbeachclerk.com. And if you visit our website, and it's app friendly, it's phone friendly. At the bottom, you have all the methods of contacting us, but sending us an email is really the most effective for attorneys and staff.
Thank you, Cindy. I'm going to have everyone do a little wrap up. So Cindy, I will start with you. If you just want to wrap up, if there's anything else that you want our lawyers to know, now's your time. And then just thank you for participating, and I'll let you wrap up your part of this.
Jessica, thank you for putting this on. This was just so forward thinking and so helpful for all of our customers, especially the bar, which is really our main, one of our biggest customers. All of our services are online, and starting May 4th, I'm sorry, our offices will be open. As the sheriff said, there are going to be a few nuances of how we open. You're going to have to stand 6 feet apart, no more than 10 people in the lobby at the same time, but all our services will be open on May 4th. As always, all electronic services are available 24/7. Thank you.
If you can mute, I'm going to turn to Ron for his wrap up. So Ron, you're going to need to unmute.
Yep, got it. Well, thank you, Jessica, and thank you for everyone who participated in this webinar. The final piece that I'd like you all to know, those of you who have CLE reporting cycles running from February through May, the Florida Bar has extended your CLE reporting cycle to August the 31st in light of the current pandemic. So just keep that in mind. And remember, though a lot of the, probably if not all of the live CLE seminars have stopped in recent time, Legal Fuel has a tremendous resource of CLE, online CLE, so you get your CLEs done. I hope everyone stays safe and keeps doing a great job, and thank you all.
Thank you, Ron. Sheriff Bradshaw, I'm going to turn it over to you for your wrap up. Any final words?
Well, it was nice to see that we had all the participants here, 67 or 70 of them. You know, it's a great group. I actually look forward to talking in front of them, but you know, maybe that's down the road a little bit. But I can't tell you how much work that the chief judge has put in to make sure that the justice system here in Palm Beach County has flowed as easy as it can. And you know, we work hard to support her, but like I said, she's been the driving force to make sure that the court system has worked as good as it can. So we're going to keep everybody safe, and I just want everybody to remember, you know, we're going to be out there, we're going to do what we need to do, and if anybody has any issues, feel free to get a hold of us, and just everybody do what they're supposed to do, and we'll get through this.
Thank you. Thank you very much for your participation today. It was incredible. And now I'll turn it over to Chief Judge MARX.
I was going to echo what everybody said. I think this was a great idea to ease everybody's minds with regard to what might be confusing. And I know the AOs have been different, but we're trying to be lockstep with the Supreme Court. The partners, the sheriff, the clerk, everybody has been unbelievable during this very difficult time and accessible at all hours of the day. So I want to really compliment them. And I want to say to the bar, we miss you. We miss you. Get on in here. Let's do it via Zoom. So I want the clear, loud message to be, we want to hear whatever you want heard. So if there are any problems whatsoever that you run into with any particular judge, feel free to email my CAD box and I will be happy to address it. Don't write me about rulings you don't like, but I'm happy to address anyone who thinks they're having difficulty setting non-essential hearings, or, you know, we're here for you. And we want to see things start to see an uptick in what we're addressing, so we don't all absolutely drown. So thank you so much. It was good to see everybody. Sorry for coming in on it late.
Oh, we got you. That was the important part. So, and just for the final wrap up, I'd like to thank our Palm Beach County Bar staff, Carla, Lynn, Kathy, everyone that's involved in getting these webinars going. I appreciate our members' patience as we work through the technical difficulties we inevitably seem to face every time we do one, but we're hoping it just keeps getting better. And we got some questions about whether or not this recording will be made available. I will find out, and hopefully we can send an update email if it is available to let people know how to access it. So members who could not attend can get this information. Carla, it sounds like she's going to address that in a second, but I also wanted to remind members that all of the AOs, in addition to being on the 15th Judicial Circuit website, are on our Palm Beach County Bar website under latest news. So if you need an easy place to go to find it, we try to keep everything there for you. So please check out our website for updates too. Carla, did you have any final words?
Yes. Well, first I want to just thank everyone for participating. We had a lot of questions we know we were not able to get to. I suspected that would happen. I want to thank our panelists. And I want to also let you know that this is being recorded, so we can get it to you if you need that. As well as we hopefully we'll have a few more town hall meetings. We've been getting a lot of requests from members who have a lot more questions about more specific divisions. So we'll work with Judge Marks and maybe get some things set up where we can hopefully be able to set up some more town hall meetings to address some of those division questions. And thank you again, Agat, for.
Were we applying for CLE for this? Someone asked about a CLE code.
I believe that was a Lynn question. I don't think she's on the phone, but I believe she may have. Yes, I'll find out for you.
Once we get that information, we'll update everyone. In the meantime, thank you guys, all of our panelists. Thank you so much for doing this. It was really helpful. And to our members, do not forget to vote. The board of directors election is going on right now, and voting ends on Friday. So please get your votes in. We have great candidates to fill the roles, and we just thank you for your participation in that regard too. So thank you, everyone.
And yes, I do have the answer. We do have CLE for this.
Okay, great. We'll send that out after the session.
All right.
Yep.
Thank you.
Thank you, everyone. Goodbye.